SJC-13218, Bask, Inc., v. members of the Taunton City Council.
Okay, Attorney Field, we're ready for you.
Morning, Your Honor. Chief Justice Budd, Associate Justices, may it please the Court. My name is George Field, and I'm here speaking on behalf of the 9 individually named members of the Taunton City Council, formerly known as the Taunton Municipal Council, whose decision is at issue in this case and in this appeal concerning a special permit for a prospective marijuana retailing facility in Taunton, Massachusetts. Standards for review of a zoning decision on a special permit take up many pages in the reports of the Supreme Judicial Court and the Appeals Court. But one of the criteria that I think is most important in this case is the determination of whether there is any rational basis for the decision.
Can I cut you off and put you to issue 2, which I'm more concerned about? The issue 2, in my view, isn't the decision on the special permit, which is certainly in contest under review here, but it's more of the remedy and the equitable relief that was provided by the judge. What do I make of Chapter 40A, Section 17's last line, where it says, "or make such other decree as justice and equity may require"? What do I make of that when I consider what the judge did in this case, the land court judge?
Thank you, Justice Gaziano. We urge on the court that that language be focused on, of course, and narrowly construed for the following reasons. The Wendy's old-fashioned hamburgers case of this court, which is cited by the applicant, tells us at note 21, Massachusetts courts have long declined to construe the statutory language, make such other decree as justice and equity may require, as permitting a reviewing court to invade the whole area of administrative discretion. Rather, the phrase merely requires a decree according to law. And that phrase is quoted from the Pendergast case of this court from 1954 to a similar
In the land court has equitable jurisdiction, right?
The land court has equitable jurisdiction within those substantive areas in which it has subject matter jurisdiction.
So I guess my dilemma in this case is, assuming for the sake of argument, I know you think differently, that the special permit was improperly withheld in the decision of the council was annulled. What then happens? Is it a paper judgment that nothing happens because they've lost their place in line, or what's the real relief to the applicant?
There was a piece of Your Honor's question which I didn't get. I just want to be sure I'm answering it the right way.
I'm sure it was Your Honor's fault, but, let me, I'll try to be more cogent. So is this a paper judgment? If they don't get the equitable relief and get to basically be part of the consideration for the dispensary license, is it just a paper judgment? They win, they should have gotten the special permit, they didn't get it, but now what?
So the premise is that the judgment of the land court stands with respect to the special permit.
Right, and then they just take that judgment and they put it on their wall?
Well, we haven't yet gotten to the point in this case where we're discussing that issue, but I think there are options that the applicant has.
Like what?
One of the options, by the way, would have been to file a certiorari complaint in the Superior Court and/or ask the land court to take an interdepartmental transfer of the Superior Court jurisdiction over licensing. I don't know whether that would have been proper, but it wasn't done. In fact, when Justice Englander, the single justice in the appeals court, was looking at the situation, he suggested more than once in his written memoranda that a Superior Court action would be appropriate. But that hasn't happened. That being the case, we are left with the question of what equitable jurisdiction, if any, the land court has over this matter. And I would ask the court, in the sense of Wendy's, to construe that phrase narrowly and to bear in mind that it was inserted in the statute at a time when, according to this court's decision in Pendergrass, the court construed these words as opening up to the court. We do not construe these words as opening up to the court the whole area of administrative discretion, contrary to all precedent. We construe them as requiring a decree according to law. And I would point out, Your Honor, that the phrase, it hasn't always been quoted this way in our materials, but the phrase that we're focusing on begins with the word "or," so that the land court may annul the particular permit in question or make such other decree as justice and equity may require. And there is case authority, and I believe we've cited it correctly in our briefs, that the real purpose of that language in this context is to give the court assurance that it may remand the matter to the municipal authority with or without instructions. And there's pretty broad discretion there, I think. So what does Bask have if its new special permit, if you want to call it that, is determined to have been properly issued by the land court? You can go back to the city and say, okay, I've got a special permit. Now, I don't have a license.
I guess the timing is the issue, right? So in the interim, the town, the city has provided a dispensary license to a place that's a quarter-mile away within Route 44.
Yes.
And now the clock is ticking, and the other 5 may have been awarded. That's, I guess, the issue, the timing. I don't know if Justice Loy has a different question than that, but that's...
Really, that's what I'm trying to figure out. So if, and maybe you've provided the answer, but if there's an issue with the city council's licensing process, and as Justice Gaziano alluded to, if there's no injunction here, when you finally get time to take a look at it, there's no locations left for dispensaries, then where do you go? And I guess your point in a nutshell is, well, the land court's jurisdiction cannot be enhanced by Chapter 40, Section 17. So if you're in this position, then you better figure something else out, like interdepartmental powers to the land court judge or go to the Superior Court. Otherwise, there's nothing you can do because the land court can only do what the land court can do.
Yes.
According, and Justice Englander's point was just that.
And the amicus brief here of the Real Estate Bar Association analyzes the reasons why one might file a special permit appeal in the land court. They're fairly obvious to most of us who practiced.
Well, but if you can file an appeal in the land court from the special permit, why can't they handle the injunction?
I'm sorry, I didn't hear the end.
If you can file that appeal in the land court from the special permit, why can't everything else that would go along with facilitating or implementing that appeal be within the jurisdiction of the land court? Why
Well,
can't they handle
it
that?
has to do, Your Honor, with the limited jurisdiction of the land court.
Well,
which-
Counsel, can I follow up on that to Justice Cypher's point? Because if the appeal can be to the land court and 185K gives the land court whatever its jurisdiction is, ordinarily, in my experience, in order to ask for the interdepartmental transfer, typically on filing the complaint, there would be counts in the complaint that are outside the jurisdiction of the land court. So prior to that, you'd ask for a designation to sit as a Superior Court judge to hear both the land court case claims and the Superior Court claims. I'm mystified by this. But the concern I had, or the confusion I had, is how is that an after-the-fact remedy that you can do and say it's annulled and we don't have the equitable jurisdiction to do what the land court did in this case. So now the land court judge goes after the fact and says, "Hey, Chief Justice, can you let me sit as a Superior Court judge now to afford this relief to the petitioner who's been vindicated?" Have you ever seen that after the fact?
I have not, Your Honor, and I'm not sure it could happen in this case at this point. I
So
suppose it would depend on how the court sends it back or makes its,
It's part of your
Final
argument that
judgment.
they filed in the wrong court, that they should have filed in the Superior Court because the Superior Court could have intervened with respect to the licensing part of it?
well, if they intended to go down the licensing path.
Because this is an
as
unusual- right,
As we've argued, there's nothing in the case that referred to licensing
Well,
until.
they're getting the permit to get the license,
Right.
right? I mean, it's
Well,
clear,
that's
it's clear they don't want a special permit unless they get a license, right? It's one and the same.
I think that's correct as you say it, Your Honor. I do want to say that there's some reference in the briefs to the sequence of these events. And if you look at the
take it
ordinance
your-
with
your-
respect to
I take it your
marijuana
argument is-
licenses in the town, it says that a retail entity or outlet can operate only if it has these three things. There's, as I think Justice Englander pointed out at one point, there's no indication of a sequence. Now, I was reading the court's.
I mean, it's clear you need a special permit to get to the next stage. So, I mean, I take it your simple argument is they go, if they go the land court route, as soon as they get the special permit, they have to immediately file in Superior Court. Is that, and then they're protected.
Well, if not if they don't want to add claims to the case. I mean,
Well, but they don't want a special permit to sell marijuana. I mean, they're getting a special permit for a marijuana license. I mean, you can't divide the two. I mean, you can divide the two if you say they have to go to Superior Court, and that may be correct. Then we're requiring another court to get completely up to speed. We're duplicating the entire process, but that may be required, but it's clear they're not getting a special permit without getting a marijuana license. They want both.
Right, and knew that, I assume, when they set out on the original course.
But does the marijuana statute sort of, it doesn't weigh in on this issue of whether you should be in the land court or in the Superior Court, right?
It does not, Your Honor. The jurisdiction is concurrent in almost all respects, but it's the question of substantive jurisdiction. I note the amicus has abandoned the Chapter 185 basis for authority to exercise equitable jurisdiction. They now focus
can I
on
ask one last
only
question?
the 40A Section 17 part. So
One last question for me is money damages, I mean, there's no discussion about, isn't money damages enough to compensate them? I'm a little confused by that. If they're denied the special permit improperly and then they lose out on the ability to participate in the marijuana licensing process, can they sue the city for money damages? Or
haven't thought about that with respect to a Superior Court action, Your Honor, under 40A 17, but in the land court, as Your Honor knows, the opportunities for money damages are very limited. I mean, they have to be
No, I understand they
specifically
might have to go
flowing.
to Superior Court, but
I'm sorry?
I understand they might have to go to Superior Court, but it just seems like if you engaged in a sort of favoritism in the permit process, I know you disagree with that, and you deny them a permit they should have gotten, and then it's too late to participate in the permitting process because you've, again, played favorites, can they sue for money damages in Superior Court, even though they got too late into the permitting process?
I don't know what the authority would be for that claim, Your Honor. I haven't considered that, but
Okay, does anybody have any further questions?
Are all the licenses gone? They're all issued?
no.
Okay, so
No, they're
there's
not, Your
still,
Honor. And it's outside the record, I think, but at one point, the city council expanded the number from 5 to 8. My understanding is that there are still 2 that are in process. This appears to be intended to be a relatively expedited process, but it really isn't, and particularly with the effects of COVID and the need to have formal meetings and hearings scheduled. It's dragged out in almost all municipalities, I think.
so a decision by this court that the land court properly authorized the special permit to be issued is not something that's, you just that they will just staple to the wall. I mean, they could go through the licensing process.
Oh, it's definitely not a nullity. I mean,
Yes.
it's up to the person who gets the relief to figure out how to use it. And that was true when the original case was filed, so.
And at the time that the judge tried to issue the injunction, that was still true? There were still pending open licenses?
I'm sorry, I can't hear. I guess I have more of a hearing problem than I thought I did, but.
No, it's probably because these are the first words I've spoken today. At the time the land court judge issued the decision trying to enjoin the licensing process of the city, there were open licenses available to the
Yes.
complainant. Okay, thank you.
And there was an avenue open, which I wasn't counsel at the time, maybe Mr. Burke knows, but I mean, a way to compromise this would have been for the city to agree to do something with respect to the outstanding licenses. I'm not sure it could have reserved one for Bask, but it certainly could have.
What are the chances of that when they've just issued a license a quarter mile up the street?
Hunter, may I say just a word about that? First thing I looked at when I saw this case was the quarter mile. And I think the applicants want us to do that. They're good advocates. And the land court bought that argument, I think.
I think the land court judge went out on a view, didn't he?
He did go out on a view, Your Honor, and he walked from this location up 0.27 miles, the same street on the same side, and then back again. And I will tell you, when he took that walk, he could not have seen any part of the other location except weeds and an open area right on the sidewalk. That is a lot that, I don't want to say it had Superfund status, but it was cleaned up at one point, all right? It's vacant. It's next to a cemetery. It's this other project, as you will see, it's in the very last page of our record appendix set of exhibits for the trial. It's that applicant's map of that property. And you will see, in terms of setback, there was some push and pull here about the setback. If you look at Trial Exhibit 4, in, I believe it's Record Appendix Volume 4, you will see that this property is almost in the road. This one that was disputed here. The setback is less than the 30 feet that the judge said it should have been. He said it's a non-conforming use, and there's no real analysis anywhere in the case that I found as to what the result of that is, or whether there was grandfathering or whatever we call it now that we don't call it grandfathering anymore, I don't know. But the setback was an important issue, and in fact, as I said in my reply brief, the president of the council rested his no vote on the articulated concern about the fact that it wasn't set back further from the road. And if you're interested in the reason for the highway business district, which I suggest you should be, our brief sets out, and I had it here 2 minutes ago.
That's okay. I think you answered my question. I just wondered if the judge had seen, I wanted to confirm the judge had seen the area.
He did take a view.
So
And
I'm satisfied.
You know what, frankly, I think the traffic jam aspect of this is blown way out of proportion.
Okay,
This is
I'm
Route
sorry.
44, there's going to be
Attorney
traffic.
Field? Thank you, you're over time. We're gonna.
Yes, I know that. Thank you,
Okay,
Your
we're gonna
Honor.
move on.
Thank you very much.
Attorney Burke?
Thank you, Your Honor. May it please the court, my name is Richard Burke. I represent the plaintiff, appellee Bask Inc. With me today is my colleague, Lisa Ramundi. Our position is that the land court's findings were supported at the trial by uncontested evidence. There was unrefuted expert opinion that there was no traffic problem posed by Bask's proposed retail store.
Burke, did you file in the wrong court?
No, Your Honor. This case started as, I was not counsel when the case was filed. However, it was filed in the right court. It was a special permit appeal. There's no question about that.
But then it has the ancillary issue of licensing, right? So had you gone to, had counsel gone to the Superior Court, you could have had that clearly had that remedy, correct?
I don't really think that makes sense to me, Your Honor, because you can't apply for a license until you have a special permit. So there was really no opportunity to make a claim for a license until the special permit case was adjudicated. And what happened here is that the city was basically doing nothing with licenses. As this case was being litigated and after it was under advisement, they all of a sudden were in a hurry to not just issue, they had issued one license. They had a total of 5 that were available, so there were 4 left when the case in the land court was under advisement after the trial. And a notice came that within days, the city planned to have all of the pending applicants for these licenses come all together and basically issue all of the licenses, with the idea being that they were going to issue licenses throughout the city and take into account where the various...
All had to have community agreements and special permits to be applicants, correct?
Yes, yes, Your Honor. Bask at that time...
Other applicants had all their ducks in a row, and they were just waiting for the city to do the licensing.
That's correct, Your Honor. They
Why
had...
at that point, when you were notified or had noticed that the city was ready to go forward with the license, didn't you then file in Superior Court, which would properly have the jurisdiction?
This was happening within a matter of days, Your Honor. I know there's been some discussion about we could have filed another lawsuit. We could have
I
sought
guess
an
I'm trying to figure out why we should hold that the land court had authority to enjoin the city in this licensing procedure, when in fact you as the litigant had the ability to go to the proper court and get that.
We think we were in the proper court, Your Honor.
Why?
Because the land court was the court adjudicating the special permit case, and from which we were seeking a remedy to reverse that special permit. At that point, we did not have a judgment. There was no judgment saying we were entitled to a special permit.
I know, but it doesn't matter if the land court's jurisdiction is right, title, interest, and land, and if the relief you're seeking under Section 4017 is beyond that, it doesn't matter, it's just as Gaziano said, that all you're gonna have is a piece of paper, because the special permit's not going to do you any good. You have to be in a court that has the equity power to address it. It can't just be, well, you know, we need this. You have to need it in the right court.
We think, Your Honor, we were in the right court.
Well,
and-
then go back to the last question from Justice Wendland. What is it about this situation that fits within the land court's jurisdiction?
The land court, as a court sitting in a zoning appeal, has general equitable powers with respect to that case under Chapter 40A, Section 17, the language of the statute, to do what justice and equity requires.
So your position, just so that I understand it, is that Chapter 40, Section 17 expands the jurisdiction of the land court.
It gives the land court equitable jurisdiction to handle remedies in zoning cases.
I know, but just my question. You're saying that that Section 17 expands the jurisdiction of the land court in this circumstance?
I'm not sure that it expands its jurisdiction, Your Honor. It gives it equitable jurisdiction, just like the Superior Court has on zoning appeals, to do what justice and equity requires, and that there really should not be a difference in the two courts, who both have statutory ability to hear appeals in zoning cases. It would not make sense to separate them.
Could it have wiped out the licenses that were already given and make the licensing process start all over again? Say it agrees with you, the favoritism is in place, so it has to wipe out, it has to allow a special permit, but at least one of them had already gotten a license, and there are a limited number of licenses, because did it have the power to, say, start the whole process over and wipe out a license you already gave?
Well, I think that we don't have to go that far, Your Honor. The land court
Well, why
never
not?
attempted to do any such thing.
If it can level the playing field, I mean, by the way, the first license that was given was the one right up the street, right?
No, I think there was the first license that had been given sometime previously was to an applicant at a different section of town, but the one right up the street was part of the group within days that was set to be part of this group that the city was going to issue presumably all of the licenses to, and that it did in fact issue 3 of the remaining 4 licenses in a matter of days.
But could the land court have just said, okay, I disagree with that, wipe out those 3? Would that be within its power too?
I'm not sure that the land court's jurisdiction to issue an appropriate equitable remedy in a zoning appeal, what the land court did here, Your Honor, was just a temporary pause. It did not step in and say, I'm vacating licenses, I'm ordering that you issue Bask a license or not issue someone else a license. It simply said, since the city has chosen to enact this 2-part process, that both with the city council as the special permit granting authority and the licensing authority, as set up by the city ordinance, the land court simply asked for a pause of the same body that was going to hear, that did hear the special permit appeal, and that the land court found had improperly denied the special permit, to simply say, pause for a moment, give Bask a brief time to apply with the rest of the group.
I understand what they did. Is there anything in the legislative history or any of the guidance from the Cannabis Commission or anything else that addresses land court versus Superior Court on this?
Not that I'm aware of, Your Honor.
And were the other applicants given notice and an opportunity to be heard in connection with this injunction issued by the land court?
No, I don't believe that they were, Your Honor. And again, and I think...
We'll agree they're interested parties, given that they're on hold now.
I suppose if they had petitioned to intervene in the matter, that perhaps the land court would have heard that. But when the judgment came out, and this is, we're just really looking to uphold the judgment, it just was a matter of a brief pause, days, that we were looking for because we needed the city council to issue the special permit pursuant to the land court's judgment before we could apply for the license, and we said that we would do that all within a matter of days. And so that's all this is about, is a very short pause, and then Bask would have had an opportunity, once it had the special permit, to be part of the opportunity with the other applicants for the citywide licenses that they were going to issue.
Is there some correlation between the December hearings on the other applicants in the case in front of the land court? Because we have, I think it's December 23rd, the land court decision comes out, and then we have 5 days later. Is it coincidental or not that all of a sudden we're having these hearings?
I think that it's not a coincidence. I think in that the land court could see that this was an attempt to circumvent the land court's judgment, that there was a rush to circumvent the land court's judgment by the same city council by simply saying, okay, forget about that case, we'll just make it moot by issuing all of the remaining licenses.
And that spurred the contempt complaint, correct?
Yes, that's where the contempt complaint comes in. It was, the judgment came out within a matter of days after getting the judgment. The city council said, we're just going to flout the judgment, we're going to ignore it, and they proceeded to hold a hearing and to issue remaining licenses.
Now, the contempt raises another sort of extension of the power, or how far the power goes, right? So don't we need clear and convincing evidence for contempt? And how do you do that on a statute where the jurisdictional issue is somewhat unclear? I mean,
I think the contempt issue is a different issue. If the court finds that there is a valid judgment, and a party intentionally violates that judgment, it's a different issue.
but does that raise some problematic issues where we're holding parties in contempt when there's a jurisdictional issue potentially in play?
Well, the city could have sought, before they just proceeded to flout the court's order, they could have asked for reconsideration. They could have sought a stay of the order. They didn't do any of those things. They just ignored the order.
You also could have gone to Superior Court and taken this up from there. I've got my special permit, and you could have solved that problem too, right?
Well, no, we didn't. At the time that, well, the court's judgment came out. When the court's judgment came out, the court's judgment said that the special permit should be ordered to be issued. We didn't have it yet. And the judgment said to the city, give Bask a brief pause and an opportunity to participate in this licensing hearing once you issue the special permit. So the judgment addressed that issue. Mm-hmm. All of the parties had the judgment. The question was that the city simply ignored the judgment.
Counsel, I'm still struggling with this, and I really don't get this from your papers or the argument. Go back to Justice Lowy's question, because if you're saying that the claim, right, the appeal, the claim under Chapter 48, right, that last sentence somehow can affect 185K, because that's effectively what you're saying. Because if you were just look to it, the enabling statute, this remedy isn't there. You're resting that on the claim. So you're saying that, so if you marry Justice Lowy's point, Justice Kafker's point, how far can this go? How far can you rely on that last sentence to just give the land court judge not necessarily unfettered authority, but just to do whatever they think is best under the circumstances as it keeps evolving? What's the limit on that?
The limit is that you have to start with a zoning case. And here, that's what we had. We have under Chapter 48, Section 17, it's clear that the land court has jurisdiction to issue orders and remedies with regard to special permits. And it has attached to that ability to adjudicate those permits, and some aura of equity around that pursuant to Chapter 40A, Section 17, so that in adjudicating special permit cases, it can make appropriate equitable orders with regard to those permits. So the authority, that equitable authority, Your Honor, would come from the same statute that gives the court the ability to adjudicate special permit cases. It's to make sure that in adjudicating a special permit case, the court's authority is not usurped, that the court can issue a remedy that has meaning, and that it can do justice.
Am I wrong that the land court also has equitable jurisdiction where right, title, and interest in land is involved, separate from Section 17?
I think there is also equitable jurisdiction related to that, Your Honor, yes. And there is some overlap between the general jurisdictional statute and the zoning appeal statute. But in either case, it's clear that the court was properly adjudicating the special permit that was at issue. The question becomes, when it comes to the point of issuing a remedy, are its hands tied, or can it issue an equitable remedy that will have meaning and effect? Or can it only issue, in the circumstances that it was faced with here, a worthless piece of paper?
But it's not really worthless, is it? I mean, one thing I'm confused by, I mean, I agree with you. The land court are the experts on special permits, so I see why you wanted to go there first. But isn't there sort of a simplicity of saying, okay, you got your special permit, and now they're giving you the bum's rush, possibly. Go to Superior Court and get an injunction, because the Superior Court's the one who deals with the marijuana legislation. So why not stick to stick to a simple approach? You got your right for the special permit, but now we're in because eventually you're going to be in Superior Court anyway, right? The land court can't resolve the marijuana case, so we're going to have two courts at the end of the day anyway. The question is when we switch courts, right?
Well, I think, again, Your Honor, when the judgment came out, the judgment addressed the issue of the order that the special permit be granted, and it contained this language that the city give Bask an opportunity to participate in the licensing process. So we had a court order at that point.
But the question is whether the land court should have gone that far or just said, here's your special permit, it's issued immediately. I can't help you any further than that. Go to Superior Court and get an injunction if they're giving you the bum's rush.
If that had been the outcome, if the court had simply said, I'm ordering that the special permit be issued, period, nothing else, perhaps then we would have had to look to see, is there some other equitable remedy we can get to pause this process?
But isn't there a simple one? Go to Superior Court and get an injunction on the next stage of this.
We already had an order with an injunction from the land court, Your Honor, and then on top of that, as a practical matter, it was clear that within days this was going to happen. So there would not have been time to file another case, ask for an interdepartmental transfer, try to get, an injunction.
Really?
This was about...
Really?
Yeah.
You don't think there was enough time?
Well, no, I don't think so, Your Honor. But we had a judgment that issued that order. So why was it not reasonable to expect that the judgment would be followed by the city in this case?
Well, if it
was my expectation.
If it was void to begin with because the land court didn't have the authority to issue that paragraph, well then...
We didn't think it was void.
Obviously, you didn't think it was void.
We believed it was a valid judgment.
You're saying you only had a few days to file something in Superior Court, and I'm questioning whether or not that's why you're suggesting that isn't enough time.
To file another case, to seek an interdepartmental transfer, to have another judge hear the case. We hadn't even applied for a license at that point.
Well, you know what? You can't do better than win. I understand why you didn't go to Superior Court. You can't do better than win. But think beyond the situation and what we're struggling to try and understand here. Which you already know is what's the limit of what the land court can do in this special permit situation when there's limits to its jurisdictional power.
Again, Your Honor, I guess that's for the court to decide the parameters of that of that authority, and we certainly adopt the argument of the amicus brief in that regard. We think that the land court did have that equitable authority to make a meaningful judgment here. And we had a judgment that said, do this. And they ignored that judgment. But beyond that, we didn't have a special permit even at that point. We couldn't apply for a license until we had a special permit. We didn't have a license because we couldn't even apply for it until we had the special permit. So what would be the odds that the Superior Court would issue an injunction in a case like that on other parties that had licenses, as opposed to going back to the land court, which was familiar with the case, which had issued a remedy to say, use your equitable authority to make an appropriate, meaningful, limited remedy, which is what the land court did.